Real people, real cases. This is Verdict Watch.
I just want to know what else you did.
There's a lot.
I want to know. Tell me.
So the walls that I removed were the existing old walls. Okay. And then I chipped around to give them an idea where the plumbing had to run. I had to retake apart. This is it. Even going to do stuff in the evening. And then the next day I got to clean up when
I want to know what you did. Just tell me what you did. I don't want to know what he did. I want to know what you did. Mount St. Louis versus Brian Marshall, 2502190R. Everybody, state their name.
It's not before Gerard Scanlon, P number 74992, appearing on behalf of the witness Brian Marshall, the president to my
Your
right.
name, sir?
Morning, Your Honor, Brian Marshall.
Mr. St. Louis, your name?
Donald St. Louis.
All right, let me just look back and file momentarily here. All right. All right. You know what? I hate this I'm filing. I just don't get it. I'm all for change if it makes it better, but it hasn't made it better. It's made it 4 times more complicated. So I don't have a small claims. This was initially filed as small claims, right?
That's correct, Your Honor.
Jennifer, have somebody bring me down the small claims affidavit. Before
pulling it
then,
up
I
right now.
before then I had files. It was a lot easier, but
Your Honor, if I may.
yeah, you can handle that.
Thank you.
All right, so I've got Mr. St. Louis claiming for labor performed. You're claiming 2789, right? Mr. St. Louis,
He returned my tools after
how much are you claiming?
just the 2,000 plus the court fine
$2,000. What's the $2,000 for?
wages for all the work performed.
Okay,
Up to the point of where we had to move to another job because 2 weeks turned into 4 weeks and it wasn't going anywhere because he wasn't.
all right, okay. Sit down, everybody. Give me your opening statement, Mr. St. Louis. You can tell me what your theory of the case is.
We working on a job on Philly and Allen Park, Carlos, my partner and myself. For him. He wrote it up and doing the job. He approached us about his girlfriend, homeowner slash lawyer. Wanted to have a bathroom redone. So, for the record, he's my stepson, you know. So I went, one night met him at Lauren's house. And she went through the whole procedure of what she wants to do, that she do this, how she'd like to have it done. And I'm like, okay, so when it was all said and done, she went around in another part of the home to water plants, and he said, well, how much are you guys going to charge? I said to do all that work, except he was going to do all the tile work in the bathroom. She's fine. I said 4,800. We had a week to go still, and then when she went on vacation, because it was a 2-week vacation she was taking, I started. The first night, the first time in there, he was in there and started helping him. And I asked him, I said, what are you doing? Are you taking away work from Carlos and I that you wanted us to do? And he goes, well, I'm just helping you get going. Don't worry, you're gonna get all the money. So I continued to go. Carlos would come when he was doing the skin work, the finishing muddy over on another job. So he'd go there for a couple hours, then come over and we work together. We completed demo of ripping out all the walls and everything.
All right, I just want to hear what your theory of the case is. He owes you money.
Right.
He owes you $2,000.
I'm being generous on that, Your Honor, because I'm going to go on, just being fair about it. For the amount of time and work I had to put in with him, including using my truck 2 times to go to Home Depot, meet him, load it up with cement, go back to her place, mix it and all that. He just, for some reason, couldn't stay out of getting it so involved in this, and there was the problem. He was supposed to supply all the materials, we could have been in and out. But it didn't happen, so we put up with it to the point where the other job, Mr. Phillips in Dearborn Heights had already, we backed him up 1 week, going into totally doing his whole remodeling of the kitchen and everything. And finally we had to go 4 weeks. He wanted 2, so we got it done in 2. I said, yes. But at no point were we supposed to deal with him being involved with, he works for major contractor. He ain't even around during the day. And then twice on weekends, he was gone. Once he took his daughter up north to visit the grandpa. Okay, that's fine. But we could not get the material to complete this job. So I figured,
To show paperwork. That's wise to be.
I figured we normally figure out jobs out at $30 an hour labor. I got at least 80 hours, actually probably more, but I settled for 80. Carlos got 12 coming there. And that there would have been 24 on me and another 340 on him, something like that. So I just went down to 2. That was it.
All right, okay.
The only, but we don't track hours. We bid a job according to what the job is worth on the market. So that's why I said 4,800, but if I had to be reasonable, because they brought it up, wanting to know how many hours, well, we don't track hours, but if I had to give a rough guess, that's where I would put it. To, you know, about 20 some, just over 20 some, or pardon me, we are 80, well, closer to 90 hours, 90. But I'll settle it. I mean, simple math.
So you're charging $100 an hour, basically?
No. $30 an hour times 80 hours. That's 2,400.
Okay,
And 12 hours for Carlos when he was there helping me with all, as I submitted into your file, as you instructed to make sure I complete the thing for the court. There's pictures there, but that's not pictures of all the work that was done. I took pictures of a
all
lot.
right, okay, let me hear from you.
Main premise of this cause of action, Your Honor, is that my client didn't supply the materials for the job.
Did,
Didn't. That's the main premise. Didn't supply the materials. That's what he said. When asked in an interrogatory to describe how the breach occurred, his answer was Brian failed to supply the materials for the job. And I've got receipts that show clearly that my client has spent over $2,000 in materials and he's prepared to testify with it. Further, I've also cited a case in my trial brief. This is the Van Dyke's case that indicates that when a job is done for a family member, which Mr. St. Louis has already testified that my client is a stepson, it's done for and gratuitously done and or furnished. In that there's a presumption that arises that Mr. St. Louis is going to have to overcome according to the case. He has no cause of action. He has no damages. My client supplied the materials, and thus we're asking that the case be dismissed and costs and attorney fees be awarded.
we did some work though, nobody's disputing you did work, are they?
That's not the nature of the breach. The nature of the breach is, according to him, in his own words, in the interrogatories that I'm going to introduce as evidence, the nature of the breach is that he failed to supply the materials. My client has receipts from Home Depot indicating that the materials were purchased and he's prepared to testify that he did purchase them.
All right,
Therefore, he has no cause of action.
call your first witness. Call your first witness. If you want to testify, you can come up here. If you don't, you can call your friend here, or you can call the defendant here, or call whoever you want. But you got to come up and, I'm going to swear you to an oath. That was just an opening statement before. Yep. Raise your right hand. You solemnly swear to affirm it. The penalties of perjury. With the testimony you give in these proceedings will be the whole truth, so help you God. Have a seat. All right, go ahead and tell me. Now you can be detailed. Go ahead, tell me everything you want to tell me.
When I went in there, they had already been doing shopping, a toilet somewhere, it was working.
Are you charging for the labor or for the materials?
Just the labor. The agreement was he's gonna supply the material when I needed it, not purchasing a cabinet here, a toilet that was all done before we even started. I mean, going in, they had stuff stockpiling, so if this material for receipts is where he's going, the only materials he bought while I was there working was copper, piping, fittings, shut-offs, the PVC 3-inch, 2-inch, and 1.5 for the drain systems. There was some lumber.
Sir, I'm asking you, are you suing for labor or materials or a combination thereof?
Just labor, sir, Your Honor.
Just labor.
Here, that's all, Your Honor.
All right. And how many hours labor did you have?
I'm saying, I think, safely say, I put it at minimum 20 hours labor. We charge $30 an hour labor. That's a very good rate in this kind of.
Okay. That's $600. How you coming up with 2,000?
80 hours.
You said 20 hours.
Oh, I'm sorry. I'm wrong. 80 hours, 2 weeks. I was there for over a 4-week stretch, in the evening and on weekends.
And what did you do in that 80 hours?
We
I'm sorry?
finished demoing all the old walls and everything. Then I had to remove piping. And there was 2 exterior walls when it come in. I ended up removing them. Copper, then I was doing rerouting copper for where it was supposed to go, the whole drain system. He cut the floor out because he was.
I want to know what you did. Don't talk about him.
Yeah.
What else?
Then I was there in the evenings helping him. Like I said.
What were you doing?
People got cement, come back, mixing cement. He took it in and doing that.
What else?
The wire, couldn't move all of it. Some
Demoed the walls, removed the piping,
repair and.
rerouted the carpet, and you went over and got cement for him. That take 80 hours to do all that?
Oh, yes.
80 hours to do all that?
Yes, you're right.
Okay, what else? Anything else?
Because there,
I just want to know what else you did.
there's a lot. I
I
should,
want to know. Tell me.
so the walls that I removed were the existing old walls. Okay, and then I chipped around to give him an idea where the plumbing had to run. I had to retake apart. This is it. Even going to do stuff in the evening. And then the next day I got to clean up when
I want to know what you did. Just tell me what you did. I don't want to know what he did. I want to know what you did.
And I loaded the trailer and hauled it to the dump, emptied it and brought it back, which I even paid the dumping fee. Which that was out of my own pocket. So all this work that I put in time putting in on this job. And many other times it was cleanup after him leaving a mess all over. That was it.
And he tell you he was going to pay you $30 an hour.
No, he agreed to pay 48 for the job, but we were
48 what?
$4,800 for the whole job. Then,
But you never got that in writing.
no, we had a verbal agreement and when he even discussed it with, talked to Carl about working over there too.
All right, go ahead.
So basically, we're just asking for the amount of work we did came to almost half of the work that was supposed to be put in, not counting Kyle.
All right.
That was his understanding and agreement.
Okay, fair enough. You got questions for him, Mr. Scanlon?
You, Mr. St. Louis, you indicated that you don't have anything to prove that this conversation between you and my client took place, correct? Regarding,
At her house or at the Fillmore?
you don't have any proof regarding the conversation that took place that indicated that my client was going to pay you $4,800 for this job. Nothing in writing.
Nothing in writing, no.
Okay, and you indicated that you don't have anything in writing to prove that my client offered to pay you $30 an hour for labor performed on this job.
No, he wanted a ballpark price for the job, which I quoted 4,800. Your Honor, can I approach the witness?
Yes. Had you worked with your stepson on work before?
Yes, we were coming off, back there, we were coming off of a house in Allen Park, Philomene. We opened up the kitchen, removed walls, redone it. I moved, electrical, plumbing. Actually, I did a lot of electrical for it. We had no written agreement. It was a verbal agreement on that one too, which
All right, okay. I just asked you if you'd worked with him before. That's good. You answered the question. You can proceed.
I'm gonna approach the witness, Your Honor, and show him what's been marked as proposed exhibit, defense proposed exhibit. Sorry. Sir, do you recognize that document?
Did you just mark that yourself?
I did, unless you're a sticker.
You know, we're gonna mark it defense one. Hand that back to my recorder, will you, Mr. Scanlon, please?
Defense one?
Yes.
Thank you. Recognize that document, sir? The whole thing? Yeah, I'll give you some time to look through it. Question. Do you have any local application?
I'm reading, it was more about supplying material. He kept,
I didn't hear a word you said, sir.
I'm sorry,
There's no question. I just asked if you recognize the document, sir, yes or no?
yes, I do.
Okay. How do you recognize that document?
Well, you sent it to me.
Okay, and these are interrogatories that were sent to you by my firm. I'd like to draw your attention. Question number 5. You can turn to that one, please.
Yeah, I got it right there.
Says, please describe in detail how the verbal agreement between you and the defendant was breached. Can you read for me your answer, please?
Brian failed to supply all material for us and continued to disrupt the work that Carlos and myself agreed to do from the agreement we made.
So that answer indicates that my client, the breach of the contract occurred because my client failed to supply the material, does it not?
Well, there was more than just that.
So yes or no question, sir?
That was part of it.
Well,
Yes
yeah,
or no?
that was the answer you gave though, right?
Yes.
Okay.
Well, there you have it.
I know. What else, Mr. Scanlon? And then this is pretty easy. I want to hear from your client.
Understood, Your Honor. I just want to put the proofs on the
All
record.
right, go ahead. Ask me your next question.
Question number 5. I'm going to ask you to produce a copy of any invoice that you sent to my client for any analysis. You didn't send him any outstanding invoices, did you, sir?
No, I wasn't buying anything.
All right. But you never sent him any outstanding balances for any materials, and you never sent him any outstanding balances for the labor work, right? Yes or no?
There is no balance for material. I was not responsible for purchasing it. So why would I send it?
It's not a question.
I don't need you to argue with him, but I got his answer. Move on to your next question.
And you indicated, sir, that Mr. Marshall is your stepson?
That's correct.
I have nothing further for this witness at this time, Your Honor.
Do you have any other testimony you want to offer? Yes or no? No. Okay, I want to hear from Mr. Marshall. Come on up here, Mr. Marshall.
Derek, I moved to with this.
Yeah. You can move to admit that. That's defense one, right?
That's defense was even.
Any objection to the admission of that, Mr.
No, Your Honor,
Defense one is admitted. Mr. Marshall, come on up here. Raise your right hand. You solemnly swear affirm under penalties of perjury, the testimony you've given in these proceedings will be the whole true self you got. Have a seat.
Your Honor,
Wait,
I do believe that what he just admitted, I already gave you a copy in the file. That's what I did.
it's fine.
Okay.
Did you hire him to do some work for you?
I did request for, I think you will.
I can't hear you. Keep your voice up. Did you hire your stepfather to do work for you?
I requested assistance for him.
Did you pay him?
I did not pay him. He was under he was gonna help me with my girlfriend's bathroom.
Did you pay him on the prior job that he had just described that he helped you with?
I did, Your Honor. That was through my construction company.
But you didn't pay him on this one.
Correct.
Did you ever stop him from going over there?
I would never stop him from going over.
Did you ever tell him, I'm not paying you for this?
I mentioned it on a text message when he called and said I owed him money for work he performed. I told him that I was gonna, it was the, if I may, Your Honor, the bathroom was for my girlfriend. It was boyfriend helping
I
girlfriend.
know, it was your girlfriend, not his,
Right, not his girlfriend.
right? Wait, well, wait. I want to ask you some questions here, and I get it. Do you have any reason to dispute that he worked on that bathroom?
No.
You heard how many hours he said he worked. He said he worked 80 hours. Do you have any reason to dispute that?
That
How
number,
many hours do you think he spent working over there?
realistic work is probably 10.
10 hours?
10, if you, I would give him 20.
Did he demo the walls?
I assisted in demoing, yeah.
I didn't ask you that.
Yes.
Did he demo the walls? Did he remove the pipe?
Yes.
Did he reroute the copper?
No,
Did he go and get supplies from time to time?
he assisted me get his,
He got cement, right?
in his truck with my.
And he brought it back there, right?
Correct.
And was your girlfriend home the whole time?
No,
Were you there every time that he was working there? How did he gain access if you weren't there and the girlfriend wasn't there?
he had a key provided by my mother.
Is $30 an hour a normal price for that work?
Yeah, that's a fair price.
But you expected him to give it to you, do this work for free?
It was a team effort. Carlos was gonna be the gentleman who came in and did.
I know, but he wasn't the girlfriend, right? I mean, you were doing this for your girlfriend, right?
Correct.
Was he friends with your girlfriend?
Yes,
Was he friends with your girlfriend before he started working on the job?
yes. He's known her for a long time.
How long's a long time?
Maybe my girlfriend and I have been together for 8 years.
How sad. You guys are father-in-law and, stepfather and stepson, and you guys are in here and,
I agree.
huh?
I agree.
Well, I know, but I don't think you've been fair with him. You want my honest opinion? I don't think you've been fair with him. You better make it 100% certain, 100% clear that you're not paying him. If you're going to have him do work, I don't care if it's on your girlfriend's, I don't care whose house it is, your friends, I don't care. Do you have any questions of him?
Mr. Marshall, you indicated that the amount of work that was done by Mr. Singh was amounted to maybe 20 hours. Correct. Not the 80 that he's indicated. Correct. And you did in fact pay for labor, or materials rather, from Home Depot.
That's it.
Okay. And you had those on your credit card statements?
Correct. The Home Depot credit card statements.
No, I opposed to witness.
Yeah, sure. I don't care what he answered on the interrogatories. But did he say or not say that he wasn't speaking any amounts for materials?
It's the basis of his lawsuit.
Well, I don't think so. It sounds to me like it's more labor. Are you not suing for the labor?
Labor only, Your Honor, time put in. For work done.
Even his affidavit, money's owing for labor performed at 23776 Carter Road, Brownstown.
Right.
I don't care what he said in an interrogatory. He's not a lawyer. He did a haphazard job. I'm not even considering materials here. I'm not awarding him anything for materials. So I don't think we got to talk about materials because it's not relevant. Unless we get into the 4,800 and you want to start talking about that. 4,800 included materials, and so this guy, Mr. Marshall, bought some of the materials, so that should rightfully come off the contract price. But I'm just telling you how I'm leaning here, and that is this guy's entitled to quantum Maryland. Whether they had a ironclad solid agreement or not, $30 in the industry is not outrageous. He clearly did some work. The question is how much work, and it has nothing to do with the materials. But go ahead, you ask, and I'll rule, and I'll stop you if I think you're going off into places that are.
Well, and I would argue, Your Honor, too, that he answered these interrogatories and indicated that the breach occurred because materials weren't paid for. Regardless of
The
whether.
first word of his claim is for labor performed.
Right.
Look at his affidavit and claim.
So what's the basis?
Hang on, I want you to look at his affidavit.
I did. What's his basis?
He said money's owing for labor performed. Why are you arguing with? I mean, that you got it. I could read this when I was 6. Money's owing for labor performed. He doesn't say anything about repairs.
Right.
I'm sorry, it doesn't say anything about materials.
So he's indicating that there's labor, yet when he answers the interrogatory.
I know. I get it. That can go to his credibility. I get it. But that's what his claim's for. And I heard everything you said, that he indicated that this gentleman didn't supply him with the materials. I get it. But I don't think he's really talked about materials. He talked about picking up materials maybe that Mr. Marshall should have picked up. Go ahead, ask your next question.
No, it's fine. I'll rest.
No, I don't, listen, I'm not trying to talk. This is a very small case. And I want to afford you every opportunity to ask whatever you want. I'm just telling you where I'm going with that. And that's what I'm going to do on these little cases. That's what I always do. And so we don't have to guess. This isn't over 25,000 or anything more, but go ahead. Yes. All right. Do you have any questions of him?
I do, Your Honor.
Go ahead.
Finished on that Sunday. And you stormed out because you wanted to run wiring, and I'm like, upset up to be gone. Now, after that day, I called you, and I said, I need the rest of my tools.
Is this a question or a
I
testimony?
wanted to verify that this is what, I asked you for money owing. What was your response to that?
You asked if I had your planner.
No, about the money. When I said you owe me $2,000, what was your response?
I don't know you really want. You locked up the job.
You said you don't have to pay me because we didn't have a written contract. Is that correct?
I don't know. Exactly. I gave her the text message, so.
When I told you that night how much money that Carlos and I would expect to do everything, and you were only gonna handle tile work at the end, did you inform Lauren about that?
Lauren was present during the conversation.
She was not present when I told you the amount of money. There was only you and I.
All right, you can't argue with him.
Yes.
You can come back up on rebuttal and tell me something different, but you can't argue with him. He's not giving you the answer you want.
Did the homeowner know that the amount of money we wanted?
Lauren was present there.
Chad calls for speculation.
That's fair. I'm gonna sustain. Strike that answer. Go ahead and ask your next question.
That's it, Your Honor.
You can step down, sir, unless you have something else. Come on back. I want to hear from you. Is this your buddy here?
This is Carlos Velazquez. Him and I have been teamed up for 27 years working together.
Come on up here. Can you spell your name for my recorder?
E as in Victor, E spelled ASQUEZ.
Raise your right hand. You solemnly swear or affirm under penalties of perjury, the testimony you give in these proceedings will be the whole true self you got. Have a seat. You know which residence they're talking about.
What's that?
You know which residence they're talking about.
48 minutes. That's the city that Brian's girlfriend lives in.
Did you do work there?
Yes.
How much work did you do?
Help Brown with doing the plumbing.
I didn't ask you that. How much work? How many hours? What did you do?
Assisted Brian with plumbing and doing a couple framings and all stuff. Right by the backside of the shower. I was at another job in between jobs, and while I was letting stuff dry over there, I would come and help Ron a little bit. That's how we work. So he would do the plumbing, electrical to get started. Then I would come over there. Then we would do the drywall. I would finish all the drywall. Then we will assemble everything. Because, you know, it's a step-by-step process doing things like that.
Do you have any questions of him?
No, Your Honor.
Do you have any questions of him?
Well, how much time did you spend on this job?
They called it 14 hours.
That's it?
Yes. We was in the middle of another job. I was finishing the other job.
Were
In
you
the
there,
process, I would go over and help him with a few things.
were you there the entire time that Mr. St. Louis was there?
I was not.
So you have no way of saying how many hours Mr. St. Louis spent on this job?
The way the job works, it's not,
Yes,
it's
sir.
like a small puzzle.
Right.
So, no, I wasn't there the full time.
So you don't have any idea how many hours Mr. St. Louis?
Just basically from what he told me every single day, Paul.
Okay, thank you.
I'm sorry, I didn't hear that.
Basically, every day he would call me and he would tell me, you know, what he did. It's just, you know,
Any other questions of him? Either one of you?
All right.
You can step down, sir. Thank you.
thank you.
Do you have any other witnesses, Mr. St. Louis?
No, Your Honor.
Do you have any witnesses, Mr. Scanlon?
No, Your Honor.
Any argument, Mr. St. Louis?
I don't know if Your Honor has had a chance to look at all the pictures that I put in the file for the court when I filed it here, the response from his attorney.
I don't look at photographs and documents like that unless they're admitted into evidence. Is there something you wanted to admit into evidence that you wanted me to look at?
That I use, enter all these as evidence,
What are those?
pictures of work that was performed.
How many pictures you have?
Oh,
How many? More than 5?
well, yes, more than 20.
I mean, I can have them marked if you want. Mr. Scanlon, any objection to me just marking all of those pictures as plaintiffs in one? You gotta lay a foundation. I mean,
There's no foundation for them and they weren't produced prior to, the court had a scheduling order on this case. He was supposed to produce those prior to, he didn't. So I would completely object to that. It's inappropriate.
Your Honor, that form that he showed you with all the questions that I answered, I also turned in an envelope inside that vanilla that had pictures exactly of what you have here. Was turned in at his.
all right, okay. Give me the pictures. Hand up the pictures. How many pictures you got? 20? Well,
Oh, do I give it to you, sir?
you tell me how many pictures you have there. Let me see. Mr. Scanlon, I could let him come back up here. I mean, what's fair is fair.
I'm sorry. Who you're on?
I'm gonna just have these marked 1. You saw all these pictures, right?
No, I have not.
You've not seen these?
No.
It's roughly 20 pictures here.
Because you don't have it, it's in
I'll let you take a look at these. And my inclination is to have the first picture marked plaintiff's 1. mark outside on an envelope plaintiff's one and put all these pictures in here. Take a look at those. You're still under oath a second here. Do these pictures demonstrate all the work you performed at this residence?
No, they do not, there is some in there where early pictures of where I was rerouting copper, and then I should have taken pictures at the last day of finished the copper run.
But all the pictures there, do they reflect the work that you yourself did personally?
They do, Your Honor, except the removal of the concrete.
Do you want to have me mark those?
Not at all. I don't even know. He just not established a foundation for that.
Man, okay, hand them back. I'm not gonna admit those. I'm gonna listen to you both argue. Tell me, what would you like to say?
Pardon me, Your Honor.
I'm gonna have you guys argue your closing arguments. Nobody else has any witnesses, right, Mr. Scanlon? Mr. Scanlon, you don't have any other witnesses, right?
No, I don't.
Go ahead.
I have no other witnesses either, Your Honor.
I know, I want to hear what argument. You want to make an argument? You don't have to.
No, other than the fact that the work was performed, his evaluation, I can understand why he wants to lowball hours, but just on the cement work for 2 times this, 10 hours of my time there.
Okay. What do you
so-
have to say, Mr. Scanlon?
Burden proof is on the plaintiff, Your Honor, to prove his case. He has the burden to produce evidence to show the court, to show the court how many hours he's actually worked. We have no testimony from any witness that would reflect that he actually performed 80 hours of work on this property. His own friend, Carlos, didn't even testify that he was there with him at the time the job was being performed. So he couldn't even verify how many hours were actually performed on this particular property. This was an unfortunate job, where, you have 2 individuals, a stepson and a stepfather, that are fighting over a verbal agreement. No evidence of the agreement, no evidence of anything in writing, no evidence that my client indicated that he was gonna pay him. I asked that this case be dismissed.
Thank you. Anything else, Mr. St. Louis?
Yes, Your Honor, if there was no agreement, why would he, tell me on the phone when I had a request payment, he didn't have to pay me because we didn't.
I don't want to hear anymore.
No,
I don't want to hear anymore.
you
If you were not going to pay him, it was incumbent upon you, Mr. Marshall, to fully and completely let him know that. Especially if you'd come off another job. This wasn't like you went to him. I heard no testimony. You went to him and said, hey, listen, Susie or whatever her name is, we've been going out 8 years. We're all close. I'd appreciate it if you do me a break on this, give me a break on this and help her out and not charge her or not charge her through me or make me eat the price of this because you're helping me. And I've got to pay you. I heard nothing like that. And I got to tell you, whether I admitted those pictures or not, based on what he told me, and I'm no construction guy, sounds like a lot of work. I have no reason to disbelieve his testimony. Judgment for plaintiff, $2,000 plus the 88 filing fee. And if you have any other fees, you have a motion fee, I believe $20, maybe not. What other judgment or fees does he have here, Jen? You have any other out of court?
Judge, I think that's it.
I think that might be defendant's motion filing fee.
It was
So, yeah,
defendant's motion.
yes, so I'm gonna make it 2,088. Can you pay this today, sir? When can you pay this? Okay. If there's a way you can go get it today, and write him a check, I can do a stipulated dismissal. If you can't, I have to do a judgment.
I get a check.
Today,
I can make it happen.
can you get it here in the next half an hour? Yeah, you good with coming back in an hour?
I am here.
The quicker the better. Mr. Scanlon, will you prepare a stipulated order for dismissal with prejudice? And then I'm gonna wait here. I'm not gonna go anywhere. And my staff's not gonna be able to go anywhere. So I'm gonna ask you to go hustle on this and we'll go from there, okay? And then we'll do a stipulated order to dismiss with prejudice once he tenders the check. Okay, thank you.
Thanks for watching Verdict Watch. New court drama every day. Don't forget to subscribe and turn on the bell so you never miss a case. Leave a comment with your thoughts. We're watching too.